I need to get some back. All rise. The Court of Appeals for the 10th District of Texas is now in session. God save the Constitution and this honorable court.
You may be seated. Want to welcome everyone. Try this again. Want to welcome everyone to the afternoon session of the 10th Court of Appeals on April the 3rd, 2024. Being held in Huntsville, Walker County, Texas. I say that partly because it is important to know kind of why we are able to do this. The legislature has authorized the court to travel for primarily educational purposes of the public so that they are apprised and aware of what we are doing and how it is done. And so it is with that admonition that we get to travel to the county seats of the 18 counties in our districts. Oddly enough, we get to come here to this university and do this. I'm a 1979 graduate, one more time, 78 graduate of San Houston. And the foundation for this building was being laid at the time that I was graduating. And so it's a great honor for me to come back and get to sit here with our faculty advisor. Mike, I don't see you in here, but most of y'all know Mike Yawn, who does coordination for this event and has done a fantastic job since we started it 13 or 14 or 15 years ago. It's been a long time we've been doing this. And so thank you all for being here today. It has been an incredible attendance today, and so thank you all very much for being here. Judge Sorensen, thank you for coming. It's good to see you. This is one of your judges here in Walker County. If you get that, shall we say, blue and red lights in the rearview mirror, and you know, there's a lot of different offenses that your friend might encounter. That you might have to meet Tracy on a professional level, but take the opportunity while she's here today. Say hello. We do things a little bit differently when we come, when we travel. There's two aspects in particular. In the old days, when there were flash bulbs and cameras and you had to position yourself and be stable and everybody's still and get a good photo, they didn't let cameras in the court. We still don't do that in Wake, but we do when we're on the road like this. But we would ask you not to use the flash and to not move around the courtroom when you're doing it. Remind me, we do let people come and go if they need to. So you can do that, but please give some courtesy to the people at the lectern to not do it in a disruptive fashion. To my right is, let's see, did I cover? No, one of the things we do that's unique to our travel. We're going to let the attorneys spend the first 3 minutes of their argument. And I would say turn to the audience, but now the audience is wrapped around the attorney. So they're going to get to speak directly to you. And what we ask them to do in that 3 minutes is basically explain whatever is necessary about their case, so that when they turn and make their legal arguments to us, it is in context for you. So it may be something about the facts or the procedure that are important in understanding of the legal issue that they will be making to us. To my right is, I'll try to remember his name this time, Matt Johnson. And to my left is the other justice on the court, Steve Smith. Sitting on the appellate court is by tenure or seniority, number of years of service, or however you want to measure it. What you will know by the way that an appellate court sits, and this goes from what I consider this 3-judge appellate panel all the way up to the United States Supreme Court, is if you identify the person that is the Chief Justice of the court and go to that judge's far right, that is the junior member, far left, excuse me, far left, is the junior justice on the court. The newest judge on the court will be on the far left. As some folks like to say, he's the one that makes coffee. And he doesn't even drink coffee. So. Earlier today, we had, President White with us. She had another meeting and was unable to be here for this afternoon's docket. In the little brochure that was handed out, it gives a summary of the cases. It's the thin document as the court, our court seal in the front. If you'll open that, pamphlet to the second page, there is a website, that is, for the case manager. If you are interested in what happens in these cases after today, that's the place to log in. You'll give the case mail program your email address, and when anything happens in any of the cases that you sign up for, you will get an email, and then you can see what document we have issued. If you are expecting to see a witness brilliantly cross-examined by the attorneys that are here today, you are going to be disappointed. There will be no witnesses. There, contrary to what this looks like over here, there will be no jury. There will be no finding. There won't even be an opinion given today of what the result is. We will, after we leave here today, we will go back to our home in Waco and research the issues that these lawyers argued, and then we will write an opinion. We will circulate it among the members of the board, and ultimately it will be issued as a public opinion that everyone gets to see. It is at that point that you will get an email, and you can go in and see what we have held with regard to this case or any other that you choose to sign up for. Also traveling with us today is two of our staff attorneys. Lindsay Adams, I can see you. I'm sure that Audrey is still over there, Audrey Sweet. These are career lawyers that work for the Court of Appeals. So if you're a student aspiring to law school, interested in what career paths there are available, there's a couple guys up here that their career path to the bench. A couple of folks over there who they work for a court of appeals. So track them down, ask them questions about how they got here and what they do in their career. Anything else, gentlemen, before we start? We have one case on the 130 docket. Like announcement from council that you are, if you're ready to go when I call the case, which is State of Texas versus Roberts.
State is ready, Your Honor. Mr. Roberts is ready to run.
Attorney name.
Patrick McKenna.
Patrick, thank you. See, he forgot to say his name too, but I knew him because I announced him this morning because he's my elected official. So, this is your Walker County District Attorney, Will Durham here, and, Councilman Ken, thank you very much. Any preliminary matters, y'all ready to go?
And I'll be splitting time with Philip Fossler today, who's the 278 prosecutor.
Okay. Now, and you may have heard my, I don't know if Philip did. Did you hear my admonition this morning that we don't need time? If he talks for the entire 17 minutes, you get nothing.
Yes.
You understand?
Yes.
Okay, all right. Just want to be sure that everybody understood it. So, at this time, if you will approach the lectern, you'll have your 3 minutes. The way we have found that it works best is the appellant does their 3 minutes and then their 17 minutes of argument. And then you'll get your 3 minutes, to speak to the audience, and then your 17 minutes of argument, 5 minutes of law.
Of course, Robert.
Thank you, Councilman.
Thank you, Judge. By the way, I'd take that jury panel any day. Good afternoon. I'm glad to have you on. My name is Will Durham, the criminal district attorney in Walker County. I want to thank the justices for the 10th Court of Appeals here today. And you say, or I want to thank you for being here. I've been fortunate enough to try 2 cases in this courtroom. In 2019, I did oral arguments in front of the justices, and back in 1993, when I was a young baby lawyer, before any of y'all were born, I tried to be a guy in this court. So it's a very nice, familiar place for me. Like I said, I think we're a little faster, you're gonna stand up, Bill. He's, assigned the 278 district court where he handled felony cases. Bill and I drafted the state brief today, it's already been filed, and we'll be splitting more arguments. This is a murder case that was tried in the 278 district court back in December of 2022. Bill was the lead counsel. Jennifer Jenkins here was one of the prosecutors also working on the case, along with myself. The defense team had to be lawyers as well. We called 23 witnesses to the stand and introduced 158 pieces of evidence. 278 district judge Hal Ridley presided over the trial, and he was the trial judge. And you hear me talking about trial judge in my argument, from voir dire through verdict. After hearing the evidence, the jury came back after 5 hours of deliberation, found the defendant guilty of murder. The next day, sentenced him to 55 years in prison and a $10,000 max fine. Notice of appeal was filed by the defendant, which is traditional, followed by a motion to new trial. Her new trial was filed on the last day of Alabama law. Their motion for new trial led to two things. One, a new evidence argument, which you'll hear about more from Phil than from me, and a new case called Hanson versus State from the 14th Court of Appeals in Houston that they say would change the outcome of the trial. As you might get, disagree with that, we oppose that motion because we believe the trial judge complied with all requirements of that new case, and there was no legal new evidence to be able to grant a new trial. After the new trial was filed, the trial judge recused himself from the case the next day, and a visiting judge was appointed. The visiting judge did not participate in any part of the trial through the verdict. The visiting judge held a hearing on a motion for new trial and granted a new trial, overturning that murder conviction. The visiting judge did not have the record of the trial yet, and he had not presided over the trial when he did this. Due to this ruling, the state of Texas has a limited right to appeal, and this is one of the reasons we can't appeal. We're asking the 10th Court of Appeals to rule if it was an abuse of discretion by the visiting judge and to deny and reverse that new trial under these specific case facts, and for the murder conviction to be reinstated. So what we're arguing today is abuse of discretion by the visiting judge.
May it please the court. Honorable Justice and fellow counsel, under the unique circumstances and timing that existed in this particular case, it was an abuse of discretion for the visiting judge to grant a new trial. The visiting judge was not present at trial and did not have a complete trial record to review when he made his decision on the new trial. The facts of this murder case are extremely interesting, but if I talked about them, we'd be here all day. So if you have questions about the actual facts, please ask me or Phil those questions. We've cited some general cases on this regarding abuse of discretion and also on new trial. There are no specific cases on abuse of discretion by a visiting judge that we could find anywhere. So this may be what we call a case of first impression. Texas law generally does state that abuse of discretion involves acts by a judge without reference to guiding rules or principles. And the guiding rules and principles here is that the visiting judge should have a full and complete record of the trial in order to make a rational and informed decision, since he was not present at trial, especially for an analysis involving a complicated Carpenter, which is a U.S. Supreme Court case, and 14th Amendment issue that should be an extensive analysis in detail. I want to take you first to the hearing by the elected trial judge on the admission of the defendant's cell phone data. After eyewitness testimony in the case, there was a long break where the trial court heard objections and arguments on the admissibility of cell phone location data. This cell data places the defendant's phone in the general area of a shallow grave where the defendant's body, where the victim's body was found, and where the eyewitness saw the defendant. The trial judge spent a great deal of time and effort in deciding this issue after considering the Fourth Amendment, the Carpenter case, the facts of our particular case, and the argument of counsel. This was also after he had heard incriminatory evidence involving the defendant, including a strong eyewitness that had seen him at the crime scene. The trial judge asked a lot of detailed questions about probable cause, being in a 2008 court order that was used to obtain the records, the accuracy of the location data, and the Fourth Amendment. He stated that he had underlined sections in the Carpenter case that discussed exigent circumstances and the exception for having not to have a warrant. He pointed out that officers were investigating a full-term missing person pregnant female at the time, and couldn't that be an exigent circumstance? The trial judge also discussed how would police be able to go back and obtain a search warrant years later after the law had changed, when they were already in possession of those documents by the state. The trial judge even pointed out multiple times about none of the officers here acted in bad faith. There was no police misconduct alleged. Now, getting a court order to obtain cell phone data was customary and proper for law enforcement from the beginning of cellular technology until Carpenter was decided by the United States Supreme Court in 2018. Only after Carpenter were search warrants required. The defendant's cell phone data in this case was legally obtained by court order in 2008. So for 10 years, it was a legal and acceptable method until Carpenter came down. And for 6 of those years, I'll tell you that the defendant in this case was a fugitive from justice living in Venezuela, or he could have been tried before Carpenter. After the trial judge had this extensive hearing, it lasted over an hour. He overruled the defendant's objections and admitted the cell phone data. I want to now go to the motion for new trial hearing by the trial judge. Like I said, the trial judge recused himself, and that was the day after the motion for new trial was filed. A visiting judge was appointed. A hearing was held by the visiting judge 2 months to the day after the guilty verdict, and this was the judge's first appearance in the case. The visiting judge first addressed the claim regarding discovery of new evidence, and after hearing that testimony and arguments that filled with detail, he stated on the record that the defense would not prevail on that issue. So then we want to go to the new case called Hankston out of the 14th Court of Appeals in Houston that wasn't available when the trial was going on. Now, in Hankston, like in our case, a court order was used to legally obtain cell phone data in a murder case. And it happened years before Carpenter had been decided. But beyond that, the facts are very different. And Hankston is not an abuse of discretion argument and appeal like this is. And frankly, our evidence of guilt in our case is stronger than Hankston had. The Hankston case made it all the way through the Texas courts up to the Court of Appeals, with the introduction of cell phone data being upheld all the way along the way. It eventually gets to the United States Supreme Court, where this time Carpenter had been decided, and they sent it back down for the 14th Court to do a Carpenter analysis in light of the new holding. Hankston is not probative to the case here about today. Why? Because our trial judge considered the Carpenter case from 2018. He considered the Fourth Amendment, and he did a Carpenter analysis in deciding whether to admit that cell phone data. Hankston does not change our case because the record shows that our trial judge did exactly what Hankston required. During the new trial hearing, the visiting judge asked what arguments were made in that suppression hearing because he wasn't present for it. He stated that he knew he needed the court reporter's record and wanted to review it to have the facts and evidence, quote, firmly planted in my mind in order to not second guess the trial judge. But that's exactly what he ended up doing. The visiting judge granted a new trial late February of 2023 without having been present for any of the trial, like the trial judge was, or having had the complete trial record to review, like appellate courts and you do. The record shows that the court reporter had to request an extension of time on April 18, 2023. That's after the ruling. And the court reporter ultimately filed a complete record on May 19, 2023, almost 3 months after the visiting judge granted a new trial. The timing of the trial judge's refusal and the visiting judge's appearance after the guilty verdict put that visiting judge in a position where he didn't have complete supporting information and data that he needed to properly decide the issue. This made his decision to grant a new trial an arbitrary one that was not rational and informed. And that's what case law in Texas says abuse of discretion is.
Mr. Durham, let me ask you.
Yes.
Is it in the record that, that the visiting judge did not have the full and complete, a full and complete record of the trial proceedings. I realize there are requests for extensions to file it, prepare it by the court reporter, but is there in fact in the record that the visiting judge did not have? Or is this just an assumption we're making because of the subsequent filings by the?
It's a circumstantial assumption we're making because we don't have, information that he had it or he didn't. He had stated in the hearing that he wanted to at least try to get a little bit of the suppression hearing to see if he could do it. But our argument is he needed the full and complete record to be able to rule on something that's important and it's detailed and it's complicated as a Fourth Amendment issue.
Your argument is that he had to have that before he could make the ruling?
In this case, yes. In every case, maybe not.
If he didn't have the full record, what was he supposed to do?
He wouldn't have been able to rule with the timing that he was given. I agree. He wouldn't have been able to
It
rule.
would have been overruled by operation of law.
That's correct.
But
That's what we fully expected.
he needed to make a ruling if he was going to make one. He had a deadline by which to make it and could not, subject to what the record may or may not show, could not have shown, or could not have available record.
That's correct. So the visiting judge actually stated he was kind of acting like a quasi appellate court, and he was not deciding the merits of the argument, but merely deciding if the trial court abused his discretion. He stated that in the hearing, and we agree with that. We think the visiting judge should have given deference to the trial judge's decision. The trial judge is the person in the best position to make a rational and informed decision. He was in trial every day. He heard the witnesses, saw their demeanor and their credibility as it was presented, and he held a detailed hearing and he ruled. We don't believe the trial judge should have been second guessed in this situation. And we're not critical of him being appointed. The judge did what he needed to do. But in that situation, he was not in a position to make a rational, educated on something that's complicated.
So in this case, would it have been impossible for any visiting judge, because Judge Ridley recused, would it have been impossible for any visiting judge to be able to rule on the motion for new trial? Because you've got time limits.
I think so, on this cell phone issue, that it was complicated, and you need to be able to do a harm analysis and a Carpenter analysis. You needed to look at the whole trial, what all the witnesses said and did, and he wasn't in a position to be able to do that. It wasn't his fault, but my position is that he shouldn't have ruled, he should have let it go. The appeal would have gone on, but he did, and our position is he shouldn't have ruled in that situation, because he just didn't have all the facts on something that's important. And that's all I have.
Maybe it's, I don't know which one of you this can fall to, and I'll ask the question and y'all decide. Is Carpenter prospective or is it retroactive?
I missed it.
Is Carpenter's holding prospective only or is it retroactive?
We do not know. It hadn't been decided.
Thank you, Judge. I do want to come back to the question you, Justice Johnson asked just a second ago. Would a visiting judge ever, under these circumstances, been able to rule? And I think I would answer if it were purely a legal question. In this case, after Hankston, if the question was, did the presiding judge conduct the Carpenter analysis? And if the answer is no, the visiting judge clearly could have said, well, you needed to do that. Case closed. When the answer comes back is, did the presiding judge do that Carpenter analysis in order to fully determine whether the presiding judge, the trial judge, abused his discretion, you would need all of the evidence. The reason, and it's come up several times, the reason we give deference to the trial judge, they're the ones in the best place to make credibility determinations. They see the witnesses, they see the demeanor, things that a cold record doesn't always accurately reflect. The odd thing about this case is which trial judge did give deference to? We had two different trial judges, and I think the answer would be clear if the reason we give deference to them is they're the ones that saw the evidence and witnesses, the deference would be given to the trial judge.
But the visiting judge is the one that heard the motion for neutral.
Yes, Judge.
And that's the ruling that is under attack today.
Yes, so the motion for new trial, there were two grounds. There was the new evidence, and in that case, because it was new evidence, he was clearly in a position to rule, and did very clearly that didn't meet the four-prong test. The second part, the inquiry was, would Hankston, or the question presented, would Hankston have changed the outcome? Our position is that the only inquiry the visiting judge should do in light of the holding in Hankston is inquire whether the trial judge did a Carpenter analysis. When the answer is yes, he did, again, he would and did say he would need the record to fully understand the reasons. In this case, in the motion to suppress, there weren't findings of fact or conclusions of law, so any theory of admitting that evidence that is supported by the record would come in. There were several different, there was, we pointed out cases and circumstances, but in addition to that, there was the argument that counsel stated in the brief brought up for the first time on appeal, but was not, that the order in 2008 was in effect warrant. The case law consistently holds that a court order is the constitutional equivalent of a search warrant as long as the court order is issued by a neutral judicial official based on a finding of probable cause and complies with the particularity agreement or requirement. Using the term order instead of warrant is merely a semantic difference. The trial judge in the case heard that argument and actually had the order itself, as now that you have all of the evidence of the record, you have that as well. So that is a reason the judge could have granted it. He could have also granted it based on his questioning under the exigent circumstance. Both of those conclusions would be supported by the record.
I thought Carpenter's distinction was that the order is not based on probable cause, but the warrant is. Is that?
Carpenter, as I understood it, that you needed to find probable cause. You needed a warrant to get these things going forward. There was a privacy interest in these things. So I agree to the extent that you need probable cause. What I'm saying is in the court order that we had from 2008, while it was called a court order, in the affidavit itself, there were sufficient facts that would have been probable cause had in 2008 you needed a warrant that would just change the order. It's the same thing. We did touch on the fact of the new evidence, and I can quote from the record. As far as the new evidence, I can easily rule that I don't find that to be persuasive at all. In fact, he would not prevail on that issue. I'm going to come back to something I mentioned a moment ago because, like I said, this was new evidence that the visiting judge was in a position to hear. It was still needed in that hearing to be pointed out to him what happened in the actual trial, because he wasn't present for that. So when the new witness was saying, I saw someone that was, she said 5'6", sometime around this, and it was pointed out from the record, the victim was actually 5'1", that came out of testimony, that helped him. So again, he didn't know the facts once he discovered that those was in the ruling. One of the things, so I'll point out, I don't have a whole lot of time here, so I'm not going to go into all of the exigencies, but defense counsel does spend some time in his brief arguing against those, and he's able to do that because he had the record. And again, that's consistently argued. Visiting judge could not have delved into what all of those reasons were for the exigencies. He didn't have that evidence. Didn't hear those witnesses and didn't have that record. Thank you.
Thank you, Councilman.
Your Honor, did the court wish me to address the audience at this time?
At the time here, where your 3 minutes is going on the time, you may proceed.
Yes, Your Honor. For all of you who are here today, my name is Pat McCann, and I hope that today we get to share all of our mutual love of the law. This case is important for 2 vital reasons. One, what does the Fourth Amendment say about the use of cell phones for locating information that is contained within cell phone tower records? And 2, what are the powers of a judge who, under the law, is assigned to fill in while another judge is on vacation, ill, perhaps had an accident and can't be attending to their duties? Does that judge have the same powers? And do their decisions have the same respect that the elected judge is given unconditionally? I believe the answer to that question is yes. I also believe that the Fourth Amendment, which was designed to protect all of you in an electronic age, we have to look at it in a new way. And the Supreme Court, in a case called Carpenter, said that the information contained in cell phone tower records as to your location is essentially a search, at least in a certain extended sense of time. The case that I brought on the motion to retrial is called Hankstead v. State. It has a long and tortured, and you'll get to hear it, procedural history. But in essence, it was a case that got sent back to the CCA in light of Carpenter. The CCA, the Court of Criminal Appeals in Austin, sent that back down to the Court of Appeals with clear instructions to consider the Fourth Amendment. They did. They decided that there was a violation of the Fourth Amendment when a warrantless search of those records was made. They applied the Texas exclusionary statute, which is Article 3823 of our Code of Criminal Procedure. It's actually a slightly more restrictive review than just the Fourth Amendment. And they decided that that evidence should have been excluded. Now, that is not binding on this court. But I think it's important to note that this was sent back to consider in light of Carpenter. The CCA sent it to the Court of Appeals, the working court in Houston. And that PDR was refused on this case. That is why I believe it's so important and was decided the week after the original trial judge made his ruling case, allowing the cell phone evidence in under the old law.
Counsel, your turn to argue. You may proceed in written.
May it please the court. My name is Patrick McCann, and I am here today on behalf of Nariah Roberts, the appellee. Mr. Roberts is here due to the fact that he won a motion for retrial in the court below. I respectfully begin this by saying that I disagree with the state on several facts, at least their interpretation. And I respectfully disagree with them on the law, and here is why. In their brief, the state goes at length to make the argument that this was not an issue of the Fourth Amendment. It was a warrantless search that was subject to the exigent circumstances. Yet, when they applied for the phone records by getting the assistance of a former Harris County District, Assistant District Attorney named Vic Weiser. That was almost 2 weeks after this woman, the deceased, had gone missing.
Was it before or after the body was found?
I'm sorry, sir?
Was it before or after the body was found that they obtained the cell location data?
I believe, it was, before, but I would have to check the record on that, Your Honor, but I think the fact that it was 2 weeks takes it out of exigent circumstances. Gutierrez and Lamb v. State, and Gutierrez is the case Lamb quoted from the CCA, said there are 3 exceptions for exigent circumstances. Immediate need for aid for someone, immediate, not 2 weeks. Safety of the officers, not applicable here. Destruction of evidence, again, not applicable here. So in their brief, the state relied upon exigent circumstances, at least as an exception as to why they should come in. Let me say now that they appear to be arguing that the court order, for which I salute my colleague for finding the case that he cited, but the fact that they make the argument that an order is the same as a warrant, having served in the military and been married, sir, I can tell you, I got a lot of orders, none of them involved a neutral magistrate deciding probable cause. And more importantly, this is, I'm not attempting to criticize, I'm simply saying there was time between 2008 and the beginning of the debates on cell phones. And even between that beginning and the return of Mr. Roberts, to get a warrant, which the state did not do. Let me also point out that the exclusionary rule, whether it is the statutory version in Texas or the judicially crafted one in federal court, is designed to make police and the state do what they're supposed to do, which is follow the preference for a warrant. Let me also point out here that as we look at this, I believe that certainly there is an argument on the other side from mine that Carpenter would not be retroactive. But by the time this case got to trial, it was the law. And that's subject to the current law, not the past. Let me also point out as we go through this, the state has asked its court, and I want to be very clear about this because I'm dead serious. The state has asked this court to create a due process violation by holding that without the full record, that every trial judge, whether visiting or recently elected, within the time frame to hear a motion to new trial, without having sat through the trial or having a complete record, would be incapable of making a ruling. And that's just wrong. You would be depriving the applicant, my client, and any future client of the ability to get a decision out of the trial court when they lawfully comply with the filing deadlines and the procedural hurdles, and they put forward facts that required a hearing. The state would have you say that this is impossible. We have to throw up our hands and leave someone who either suffered from an unfair trial or could be actually innocent, rotting in prison. That is not how to run a motion for new trial.
That raises a question of what happens in the event that we were to agree with the state in this appeal and set aside a new trial and remand it for, a judgment which apply the jury's verdict.
Well, so since the original trial judge has recused himself, I know of no circumstance where that can be undone. So a new visiting judge has to hear that from beginning to end if it's set for trial. If you set it back to where the conviction is, then I honestly don't know. And I guess this gets to the place that I'm arguing, sir, is that the legislature crafted the judicial administrative code for a reason. There is nothing in chapter 74 of that which governs the assignment of visiting judges that limits their powers, other than the term and the order that must come from the presiding administrative regional judge saying that visiting Judge Y will sit from October 1 to October 15 in whatever number district court. That order is the only thing that limits their jurisdiction and powers, because otherwise, according to that, this should be the exact same as having a seamless transition every day in the 254 counties of Texas. We have visiting judges who hear jury trials, select juries, and then hand it off to the presiding judge. Handle the administrative or normal criminal docket while the presiding judge is in trial, and accept pleas for terms of years from 2 to life. Every day. And to say that without a full record, a visiting judge properly assigned and unobjected to by my colleagues at the time cannot make a decision on an item lawfully and properly in front of him or her is to cripple our judicial system. Quite frankly, it means you all can never leave, and you can never go on vacation, you can never miss sick. That is what they're asking you to do, and that is a radical upending of a legislatively approved set of laws.
Now, he's gonna get up here in rebuttal and say, it's unique to this situation, but where we need the entire trial record to rule on a motion for new trial.
Well, first off, they're wrong, and here's why. The court reporter was available at that time, and the court reporter's notes, as this court well knows, are acceptable as long as they're read back by the court reporter. And she verifies or he verifies that that is the transcription, because they're the ones who took the notes. We use that in pretrial hearings to make sure that we understood the officer's testimony on a suppression. We use it for jury readbacks when there is a disagreement about what the testimony was. I can think of nothing more important than that in their decisions. It is obviously available to the visiting judge to have that person read those back. And yes,
But we don't know, based on this record, whether the judge did or did not.
and respectfully, that's the state's fault, because the state failed to seek findings and conclusions as the losing side, as they are entitled to do. And as I have done, and as I'm certain members of the court when they were practicing have done, the losing side is entitled to seek findings and conclusions from the judge as to their reasoning. State did not do that. The state did not ask for a hearing to get those findings on the record, request them in writing, submit them. They did none of it. And so they have failed to present this court with a record supporting their claim. And that was available to them throughout the months of preparation coming up to this oral argument. And in that case, I respectfully put it to this panel that this is not only something within the zone of reasonable disagreement, their own pointing to the record of the original trial judge should tell this panel that this was a close issue. It was a close issue to start with. And more importantly, it was something that the original trial judge wrestled with without the benefit of the Hankston case, without the benefit of the testimony at the motion for new trial of the impact and the harm that the cell phone tower locating information had on the jury, and without the factual witness who came forward. Now, I do agree that with my colleague that the motion for new trial judge indicated that with the fact witness alone, Mr. Roberts would not have prevailed. I would respectfully disagree that we lost on that issue, or that the judge didn't somehow bring those two problems together and say this was time with the Hankston case, which the first judge didn't have handy, and with the facts that came out, which was a witness who saw a pregnant woman matching the description of the deceased walking alive on the road after Mr. Roberts had claimed he let her go out of the car because of having heart. So I would respectfully disagree that that wasn't a factor, and more importantly, the state could have asked. They failed to take the opportunity to give this panel a reason or some factor or improper legal reasoning that would justify this court going back to the fact finder, the judge who heard the motion for new trial and made credibility determinations on those witnesses, and overturning that decision. Because again, because the state disagrees with something is not an abuse of discretion. Abuse of discretion has to be that reasonable people and jurists would find this outside the zone of reasonable disagreement. That's the standard in Paramouche and the state. And I think that this court owes that to the visiting judge for a number of reasons. One, because of what I just said, but two, because to fail to support the visiting judge's powers granted under the state law by the legislature is to cripple your own system at the request of the state to uphold this conviction. And if they are so confident in their evidence, their vast tower of evidence, then they don't need this. And they can go back to trial as the trial judge that sat as a visiting judge told them they had to.
Then without evidence that the trial judge did not have access and had reviewed the full record, without any evidence of that in our record, do you think we should give the trial and visiting judge the presumption?
Yes, and it's an excellent question, Justice Johnson, but here is why I believe that's important. While my colleagues are correct that the visiting judge did not have the advantage of having seen the original witnesses, we do know from my colleagues and from the transcript of the original trial proceeding that the issue was one that sat on the conscience of the original judge and was not an easy decision. Therefore, to me, this comes within the zone of reasonable disagreement. And just as one would have extended presumptions on a suppression hearing, on a motion for new trial. And in particular, with the fact that the Hankston case came down right after. And that issue, that's rare that a case comes out immediately after, within the motion for new trial filing period. But I think you have to give the visiting judge, for reasons of pragmatism, for all visiting judges, so they know they have the power, for the reason that, yes, there was a unique circumstance because there was a case that came down for that judge to review that the first judge didn't have. And last, because the state has failed to bring you the information that would have been required for you to overturn this. In other words, findings and conclusions which are not supported in the record or which were on their face wrong. And that's the only way I believe that you can go in and overturn this. And let me be clear, no one ever has a complete record in front of them on a motion for new trial. There is never time for that. So the fact is that if the original trial judge had stayed on, although he would have had his memory, he would not have had a record either. And if this occurred over an election, which we're going to be facing this year, and there was a new judge, and a motion for new trial was filed in December, that person would have 2 months in their new term to make a decision without the benefit of their memory or a record. So unless this court is prepared to turn this system on its head at the state's request, I would respectfully submit that the appeal should be denied. I see I'm out of time, Your Honor. Does the court have any further questions?
What was the visiting trial court's task at the motion for new trial period?
What was its task, Your Honor? To evaluate my grounds for bringing the motion to trial and determine if I could show that there was a reason in the law or in the facts, or both, to overturn the jury verdict. That's why they're there as a fail-safe.
Was his job any different than if Judge Ridley had not recused himself?
No,
What was his scope of review for that task?
I would say both were the same. In other words, whether it was the original trial judge or whether it was a new trial judge, both had the same scope. They have to, otherwise you can't get a fair review of your motion for new trial. Because if that were the case, then we are creating a due process problem because in Trevino v. Washington, the Supreme Court has said that hearing on a motion for new trial is a critical stage of proceedings. If you deny a judge a chance to correct a mistaken or now changed conviction because of a new loss or because of a new case, then you are essentially creating a due process problem within our own system that we don't.
What is our task on this appeal?
I appreciate the question, Your Honor, and I want to put it to the panel quite simply. Your task is to see if the state has given you reasons in law and facts to overturn the assigned, properly assigned, unobjected to, qualified visiting judge and his decision. They have not provided that information to you, and they have not met the burden that I believe they have in this as appellate to provide you with record and authority and the law to overturn that decision.
Does our task in any way change based on the fact it was not Judge Ridley that granted the motion for new trial?
No, and it can't. If we begin to decide who had the right record, who had enough record, or who had a finally reviewed record, did they have enough time? You are becoming, instead of a reviewing court, which needs a reason to overturn a fact finder, you have become instead a district court management agency. And that is not respectful of this panel's function, nor it should ever be.
So basically, your position is whether it was decided by a visiting judge or Judge Ridley, our task remains the same.
Yes, Your Honor, that is exactly what I'm saying.
Thank you, counsel.
Your Honor, if I may, I wanted to take a moment, to thank the court for this opportunity to advocate for my client. It's a unique circumstance, and I'm grateful to the court and proud of it. Thank you.
Thank you, counsel.
I will tell you, just like you said, this is a very fact-specific situation. This is not going to be any kind of ruling if it goes in our favor that upturns the whole visiting judge system in Texas. In fact, I'm a big fan of the visiting judge system in Texas. We need them to help move our dockets, especially in multi-county places like we are here. This is very fact specific. There are certain times where maybe this visiting judge could have ruled at that time in certain situations, but we're talking about a very complicated Fourth Amendment argument with a Supreme Court case that needed to be really well looked at. And what you're looking at is, for instance, if Ridley wanted to try to determine if it was harmless or not, he would have to look at what all the other witnesses said. How good was that eyewitness? That kind of thing. I disagree with counsel that said it's the same with either one of them, because the visiting judge, he either had some little clip from one of the court reporters, or he didn't have anything at all. Judge Ridley saw these witnesses, heard them, and could be able to go, that's an exigent circumstance. Whether he's right or wrong is not what we're deciding here today. What we're deciding is it was abuse of discretion for that judge, the visiting judge, and what he did not have to make the ruling. If you were to rule that it was an abuse of discretion, we go back to the merits of the case. And the merits of the case are many of the things that defense counsel was arguing, things that we would get into in more detail. What about exigent circumstance? What about harm analysis and those kind of things? Would the jury have found this particular man guilty, even if the cell phone records weren't there? So I just want you to know, this is not some attack on the visiting judge or an attempt to make any kind of add-on. In fact, and the fact that we didn't ask for finding the fact conclusion of law, it wouldn't have been in there what he reviewed or didn't review anyway. He would have just stated certain facts that he believed supported what he was doing.
We don't know what would be.
No, we don't know that, but we have clues from what he said and stated categorically in the motion for trial here.
At what point in the trial did Judge Ridley make the decision to admit the records?
It was about 3/4 of the way through the trial. I think really the only last witnesses we had a person testified about the Bible that was found in the trunk and on the deceased body. And I had the last witness that came in with the FBI that went and got him out of Venezuela and brought him back here to trial. So you had most of the incriminatory evidence, the shoes that were found in his house, similar clothing, the car that matched the description, and the eyewitness that said that's him. And that eyewitness was important, was not in some attack situation. He was helping a guy out of the mud. He was with him about 20 minutes. So all those things are things that really looked at when he made his decision.
But my point is Judge Ridley didn't have the entire record in front of him when he made the decision.
Well, but he did have a lot of witnesses that he had seen firsthand. But
I understand that.
I agree.
He hadn't heard from all the witnesses. He didn't have all the trial testimony for him when he made his call.
He had the majority of the testimony linking the defendant to the crime scene at that time. And I just like to say that, so this is a very fact-specific situation, and this is gonna have no way to affect on the visiting judges and how we do things here.
Let me ask you the same question.
Yes.
Opposing counsel, what happens if we agree with you?
If you agree with me, then what would happen is it would get reinstated, and then I think
Be
they
more specific on what would be reinstated.
the conviction and the 55-year prison sentence for murder would be reinstated, and he would file the appeal, notice of appeal like he had already done, and it would go up on what Ridley did in the trial and letting the cell phone evidence in, and was that a, some kind of an error. If we go up on the merits of that, and not on abuse of discretion. So we would have another appeal where we'd argue, some of the things he's arguing today, they're not part of this. This is about abuse of discretion. This is about what he did not have when he made that ruling. So to me, it's very fact specific.
But again, you're arguing that the trial court abused his discretion in granting it because he did not have the record of the full trial.
I believe that, except the visiting judge.
I'm sorry.
The visiting judge, right. Ridley did the right thing. He was in a position to be able to rule, and he did. And I commend him for that. And it shouldn't have been second guessed by the trial visiting judge, who I don't have any problem with, except for this particular specific fact situation.
Do you agree with the opposing counsel that it makes no difference to our task if Judge Ridley had made this ruling versus the visiting judge?
I think it does make some difference because, and I'll quote you, it said, you know, in the 10th Court of Appeals opinion of Berrigan, y'all had, it said, to some extent, the trial court must act like an appellate court. And I would say the visiting judge should have acted like an appellate court. An appellate court is always going to rule with a complete record if they haven't been present in the trial. So I disagree with him. I think because he's a visiting judge, it's different in this case because of what he did not have and did not see and did not know.
Do you have 30 seconds you want to sum up? Or are you good with your?
Well, I just appreciate y'all being here, and I think in this particular fact scenario, the visiting judge should have been given deference to the trial, to the trial judge's decision and the jury verdict, like appellate judges do, like you do. The record shows that visiting judge was not in a proper position to rule for a new trial. He didn't have a full and complete record like the appellate court does, and he didn't see and hear the evidence and witness testimony like the trial judge did. He was just sitting there with his hands behind his back. It wasn't his fault, it was the timing, but he should just have let it go by operation of law. And then it's a different appeal, we're still going to be fighting, but it wouldn't be on this issue.
Thank you. This case is submitted. You all review. At this time, the court is in recess, but we're going to have a couple of minutes to let everybody get out. It's not interested in staying, but if anybody is interested in asking us any questions because of the reasons for which we travel, we'll stay here until the courtroom kind of clears and then try to answer you. So, y'all head out if you want.
Odd if we kind of stood here and got a picture.
We're gonna put you in the middle and we're gonna hold it back.
Thank you.
Stagger. Okay, we'll get. How's that?
It'd be better if we was in one.
Am I here?
No, we're back up there. You blocked him out. Thank you.
All right. See you. Take care.
Okay.
Isn't that crazy that I tried a DWI here in '93? The courthouse was like shut down or something for a leak or a pipe or something. Place has been around a long time and you saw it being built by the inmates.
Remember, yeah.
Yeah, yeah. Well, I was, so am I. I was around, I saw it too. I remember the inmates building it. It's very well built, like our building was built in 31 during the Depression time, and I've got pictures with people with hard hats on building it. It is built so well compared to things today. Interesting.
Yes, I'm pretty one to the heart.
Well, we did training with the public today, that's why we missed the 10 and 11, they were doing it for the whole study. Now, I didn't want my good folks to get that. Yeah, they're all. Ready?
Yes.
Jackie, you're
Okay, 1, 2, 3, 1, 2, 3, and 1, 2, 3. We got it. Justice Gray, here we have a civil lawsuit next year that will be in here for negligence. You will be a witness and maybe a party.
I could, I guess.
She told me you tripped her. But here's the good news. There are approximately 3,000 witnesses to her trippings on a daily basis. So she has a reputational factor that will be difficult to overcome.
I think it's an obvious defect personally. Hey, what's up, you?
I did not see you. I didn't, that's the second time I see you. I'm sorry, but I did not watch. Our reputation. Full day. So things that are really nice. We got to see. Oh, yeah. Like.